Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court acquitted an accused based on Section 313 Criminal Procedure Code statement and summarized legal propositions. A division bench of Justice Ravindra Bhatt and Justice Dipankar Datta established that Section 313 is a safeguard for the accused to prove his innocence, which mandates the court to question the accused so that he can personally explain the circumstances appearing in the evidence against him. The accused may deny the allegations directly or may admit some circumstances and can make some statements without fear of cross-examination. No conviction can be solely based on Section 313 statement as it is not an evidence under the Section 3 of the Evidence Act. The whole statement has to be considered and not isolated parts. The Supreme Court has opined that allowing both the applications under Order VII Rule 10 and Order VII Rule 11 of the Civil Procedure Code is erroneous. If a plaint is rejected as per Order VII Rule 11, then the only recourse is to file a fresh plaint under Order VII Rule 13. And the question of presenting the same plaint before the court as per Order 7 Rule 10 does not and cannot arise. The court observed that if a plaint is rejected as per Order 7 Rule 11, then the only recourse is to file a fresh plaint as per Order 7 Rule 13. The Supreme Court propounded that a breach of contract does not give rise to criminal prosecution for cheating unless the fraudulent or dishonest intention is proved right at the commencement of the transaction. Criminal proceedings cannot be initiated merely because it has been alleged that the promise was not kept. In the appeal preferred seeking quashing of an FIR under Section 420, 120B and 506 of the Indian Penal Code, a division bench of Justice Abhay S. Oka and Justice Rajesh Bindal remarked that it was an attempt to convert a civil case into a criminal one. The Supreme Court has referred to a larger bench the legal issue of territorial jurisdiction of High Courts to decide a challenge to an order of the chairperson to the Central Administrative Tribunal's principal bench in the national capital. The division bench of Justice M.R. Shah and Justice B.V. Nagaratna stated that the issue affects a larger number of governmental employees and is of public importance. The Supreme Court has refused to entertain a public interest litigation petition that sought the removal of a statue of Manu, a mythological figure and lawmaker in Hinduism, from the campus of the Rajasthan High Court in Jaipur. The statue depicted Manu holding the Manu Smriti, which is an ancient legal text in Hinduism that has been criticized for its treatment of women and lower castes. Next we have Delhi High Court. The Delhi High Court has held that the order of ASG directing registration of FIR against TVF and director of the show College Romance under Section 67 and 67A of the Information Technology Act for use of obscene, profane and vulgar language. The single-judge bench of Justice Swarna Kanta Sharma said that during deliberation of the material facts, she found it hard to watch the show and had to use earphones in the chamber as the profanity of the language used was such that it could not have been heard without shocking or alarming the people around. The court remarked that keeping in mind the decorum of the language which is maintained by a common prudent man, whether in professional or public domain, or even with the family members at home, it could be inferred that the language used in the web series is not the language of the nation's youth or otherwise the citizens of the country, and this language cannot be called the frequently spoken language used in the country. The ACMM had directed the police to register FIRs against the petitioner under Section 292 and 294 of the IPC and Section 67 and 67A of the IT Act, but the ASG later dropped the penal provisions. The Delhi High Court has allowed the plea of Vistara Airlines to put an interim stay on the use of Vistara mark by the construction company Vistara Buildtech. The single-judge bench of Justice C. Harishankar observed that Vistara is a coined word which has no known meaning or etymological significance, and the plaintiff Airlines has been using the same since 2015 while the defendant came into existence only in 2020 and are yet to commence building operations under the impugned marks. The plaintiff, therefore, also has the advantage of priority of the use of over the defendants, the court ruled. Now let's have an overview of other high courts. The Rajasthan High Court has held that single judge of the High Court cannot pass discretions contrary to the orders of a division bench. A division bench of Justice S. Vaidyanath and Justice N. Anand Venkatesh thus observed that single judge's observation running contrary to division bench order in collateral order must be disregarded in view of law laid down as it is beyond the jurisdiction of the former. The single judge bench in revision petition filed by an American citizen seeking quashing of proceedings initiated by his estranged wife before a Mahila court in Chennai ruled that even persons who were living temporarily in India were entitled to invoke the Protection of Women from Domestic Violence Act 2005 before Indian courts. He argued that the proceedings initiated by his wife here in India are not sustainable in law. It was further submitted on his part that in a habeas corpus filed by him with the court, a division bench has already ruled that the son should go back to America and join him as observed by the court of local jurisdiction therein, and therefore it is not open for the single judge to re-examine the issue. The court in the present contempt petition ruled in favour of the husband, stating that the single judge extended his jurisdiction. The Kerala High Court has ruled that examination of a witness via video conferencing doesn't affect the rights of the accused. The single judge bench of Justice A. Badruddin in this view dismissed petition filed seeking physical presence of the witness for effective cross-examination, while CBI had sought for his virtual appearance under electronic video linkage rules for courts Kerala 2021 on the ground that the first witness has been working in Dubai and his presence for examination could not be secured without delay or expenses. The court negated the objection and pointed out that cross-examination of a witness either through video conferencing or through physical presence would be equally effective, and there is no need to discriminate the proceedings in any manner and to make the rules inoperative, stating that since the purpose of enactment of the rules itself is to examine the witness whose presence could not be secured without undue delay or expenses, and for other reasons, the court established that the petitioner has no right to say that the cross-examination of video linkage is not effective and as good as physical move. Therefore, such examinations should not be permitted. A single judge bench of the Madras High Court comprising of Justice Krishnan Ramasamy, while entertaining a dispute under the Arbitration and Conciliation Act, observed that even though there was an express clause in the contract mentioning that 9% interest has to be paid by the respondents, the emails and other media could be considered as a record for the said agreement between the parties. Further, as per Section 4(b) of the Arbitration and Conciliation Act, an exchange of letters, telex, telegrams or another means of telecommunications provides a record of the agreement, the court stated. The Allahabad High Court has held that a woman can also be held guilty of gang rape if she has facilitated the act of rape with a group of persons. The court, after going through the amended provisions of Section 375 to Section 376 EIPC, observed that the argument that a woman cannot commit rape and therefore she cannot be prosecuted for gang rape is not correct. In order to establish an offence under Section 376 DIPC, the prosecution has to adduce evidence to indicate that one or more person has acted in concert, and in such an event, if rape has been committed by one, all accused will be guilty irrespective of the fact that the victim had been raped by one or more of them, the court clarified. The provision embodies a principle of joint liability, and the essence of that liability is that existence of common intention, and that common intention presupposes prior concert, which may be determined from the conduct of the offenders revealed during the course of action, it added. The Chhattisgarh High Court has held that merely because the victim is a member of the scheduled tribe community, it cannot be assumed that the accused was able to dominate her will to exploit her sexually. The division bench of Justice Sanjay Kumar Agarwal and Justice Sachin Singh Rajput in an appeal modified the sentence of the accused to 10 years from 14 years, considering the Supreme Court dictum in Vipul Rashibhai Kohli Jhamkhar versus State of Gujarat 2002. The court noted that the appellant had also been convicted of offences punishable under Section 317 of the Act 1989 prior to its amendment, and therefore it must be proved that the accused was in a position to dominate the will of a woman belonging to a scheduled caste or scheduled tribe community and uses that position to exploit her sexually, to which she would not have otherwise agreed. Moving on to miscellaneous news. A family court in Delhi dealing with the divorce petition of cricketer Shikhar Dhawan against his estranged wife Ayesha Mukherjee has rebuffed the Australian court for making imperious remarks against the Indian courts. The Patiala House Court noted that foreign courts should shed the attitude that courts in India are still in the pre-independence era. The judge reminded his counterparts in Australia that Indian judicial system has grown tremendously and particularly progressed in the fields of adaptation to technology over the past few years. The remarks were made in response to Federal Circuit and Family Court in Australia asking Dhawan to submit its jurisdiction to Australia and withdraw petition filed in the Family Court in Delhi. They had stated that they had no idea how Indian courts function and adjudicate parenting disputes or custody matters, and thus suggested that since both the parties understand English, they can continue to pursue their litigation in Australia instead of India, as the former uses video conferencing. The Bar Council of India has expressed its strong condemnation of the statement made by Mr. Abhishek Manu Singhvi, senior advocate, during his recent speech in a function of American Bar Association, whereby he suggested formation of a body independent of the BCI to regulate legal education and legal profession. The BCI has said that ABA was misled and hinted that Mr. Singhvi appears to be under the influence of a very small group of law teachers or managers of private institutions who frequently visit foreign countries and project themselves to be the harbinger of Indian legal education and legal profession. Remarking that Mr. Singhvi makes gains from dancing to the tunes of those managers, the Council stated that it has long been ignorant and patient about such statements. The Apex Court has expanded the scope of a high-powered committee dealing with the transfer and transportation of elephants bred in captivity in the northeast, giving it a pan-India mandate to deal with any approval or grievance regarding the transfer, import into India, or procurement of wild animals by any rehabilitation center or zoo in the country. The Rajasthan High Court has sought response of central government, state government and the Bar Council of India on protection of advocates from violence, harassment and threats, etc. The court is inclined to issue guidelines on the same as it dealt with petition pending since 2020 seeking framing of an appropriate legislation for the protection of advocates. The court took cognizance of the recent incident wherein a lawyer was murdered in the broad daylight on his way back to home. This triggered the state lawyers who went on to stage a protest demanding steps to be taken for their protection. The Allahabad High Court has issued a notice to the Attorney General of India on a public interest litigation filed by the Hindu Personal Law Board seeking declaration of Section 494 of the Indian Penal Code as unconstitutional as it is, according to the petitioner, discriminates between people on the basis of religion. Under IPC Section 494, if a person marries for the second time during the lifetime of the first wife or husband without getting a divorce, the marriage is void. For this offence, there is a provision for 7 years jail term and a fine. The law is applicable to Hindus, Sikhs and Christians but not to the Muslim men who have the right to marry 4 times under the Muslim Personal Law Shariat Application Act 1937. In the end, we have international news. British Prime Minister Rishi Sunak has announced a clampdown on illegal migrants with a new proposed law to tackle the issue of migrant crossings over into the UK illegally and dangerously in small boats from across the English Channel. Rishi Sunak had made cracking down on this illegal route between the UK's sea border with neighbouring France among his top priorities for the year. Along with his Indian origin Home Secretary Suella Braverman, the Sunak-led government is now planning to table the legislation in Parliament to address the issue. 5 airlines are suing the Dutch government over plans to cut the number of flights operating from Europe's third busiest airport. The government cited local concerns at Amsterdam Schiphol about the impact of flying on noise pollution and climate in its decision. Women will soon be allowed to swim topless in Berlin's public pools after a ruling by the city's authorities. It comes after a woman who was thrown out of an open-air pool for sunbathing topless took legal action. And another woman said she was also told to cover up while in indoor pool in December. Authorities agreed that they had been victim of discrimination and said that the visitors to Berlin's pool were now entitled to go topless. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.